Today, and by popular demand, I'm going to talk to you a little bit about hearsay, both in a criminal context and a civil context, although most people think about it in a criminal context. Welcome to my channel, I'm Daniel Shensmith. I'm a barrister of England and Wales. If you're new here, please subscribe and hit the notification bell because you won't get notifications otherwise. And please like this video because that really helps. So in order to understand hearsay, it's necessary to think about it in context and from a historical point of view and the rationale as to why hearsay is thought about in the first place. From a historical perspective, common law excluded statements that were not made in oral evidence. This is because the person making the statement was not in court to be cross-examined, and therefore the evidence could not be tested and it was considered to be less reliable. The best way to think about this is rumours. If somebody told you something directly from their own experience, you're likely to believe it. But if they are telling you a recount of a story from someone that's told them, it's a little bit less reliable because it's already one step removed. If you extend that chain on and 3 or 4 people have told the story to each other, then this is where rumours start and the story can get distorted. That's why it would be less reliable if your friend tells you that their friend told them that their cousin was told by their neighbour who heard it somewhere else. That's not going to be a very reliable source of information. The law on hearsay is set out in the Criminal Justice Act 2003. The meaning given to hearsay under the Criminal Justice Act is a statement not made in oral evidence that is evidence of a matter stated. But Section 115 of the Criminal Justice Act makes this a little bit more complicated. In this chapter, references to a statement or matter stated are to be read as follows. A statement is any representation of fact or opinion made by a person by whatever means, and it includes representations made in a sketch, photo fit, or pictorial form. In other words, hearsay doesn't have to be the spoken word. It could be a drawing, writing, or anything else of that nature. But it goes on to say that a matter stated is one to which this act of law applies if and only if the purpose or one of the purposes of the person making the statement appears to the court to have been as follows. A, to cause another person to believe the matter. B, to cause another person to act or a machine to operate on the basis that the matter is as stated. In other words, it must appear to the court that the purpose or one of the purposes of making the statement is to cause somebody else to believe it or to act on it or a machine to operate on it on the basis that it was true. The precise meaning of this part of the Act is a difficult concept for most law students to grasp, let alone the general public who are not even trying to study law. Let me give you an example and you'll see what I mean. Imagine for a moment we have a defendant in court on trial for a crime that he's committed. Let's say in his defense he says, I only committed this crime because I was being threatened. These people said that if I don't do this, they are going to kill me. Now, if this defendant is giving evidence as to what these people said, many people might think, well, that's hearsay because they are not in court. For obvious reasons, they are never going to come to court to give evidence as to what they've said. But on a careful reading of the law, the definition of hearsay as a matter stated is to cause somebody to believe or to act or a machine to operate on the basis that the matter stated is true. So taking this definition into the words of the threat, is this defendant trying to convince anybody that the words spoken were true? You might say yes, because he's saying that he only committed this crime because of this threat that was made. However, if he's not seeking to convince you that what was said was true, that they would actually go and kill him if he didn't commit this offence, if he's only trying to convince you that a threat was made rather than the truth of the words contained within the threat, then that in and of itself is not hearsay, because he's just giving evidence that a threat has been made. And it's on this basis very often that evidence of words spoken outside of court become admissible, because the party adducing the evidence is not seeking to prove that the contents of it were true, only the fact that those words were made. In addition to the way the evidence is sought to be admissible in court, there are some exceptions. For example, under Section 116 of the Criminal Justice Act. Under this section, evidence of words spoken outside of court will be admissible if the person was in court and the court can identify the person and one of the following exceptions that must apply. Firstly, if the person is dead. Secondly, if the person is unfit to give evidence due to their bodily or mental capacity. Thirdly, if the person is outside of the UK and it's just not practicable to bring them to the UK. Or in the event that they just can't be found, but reasonable steps have been taken to find them. And finally, if the person is in fear. But an important distinction under this section is that the court must be able to identify the person. It cannot be anonymous hearsay under this section. It was also decided by the Court of Appeal in 2005 that if a defendant is either proved or highly likely to have intimidated a witness to the point that they don't want to give evidence out of fear, then that defendant cannot complain that he's been denied the right to a fair trial by being denied the opportunity to cross-examine that witness. There is also an exception under Section 117 of the Criminal Justice Act, which refers to business documents. There is also an exception under Section 114 of the Criminal Justice Act, which is in the interests of justice, but there are lots of rules around this as well. Section 118 of the Criminal Justice Act is the res geste exception, where somebody is overpowered by an event or emotion. For example, they scream out in pain or something of that nature. As you can see, this is already very complicated, and this is only an overview of what hearsay is and the gateways or exceptions to admitting hearsay. For those of you that are interested in a much more in-depth analysis of hearsay and other areas of law, don't just subscribe or like the video, but I will be starting channel memberships where you can join for exclusive videos that won't be publicly available. But do subscribe if you found this video interesting. Thank you for watching, and I'll see you next time.